Ya Ali Madad, welcome to our discussion this evening. My name is Rosemin Amirali Visram. I am honored to be the moderator for this webinar. Thank you for joining today's discussion on managing contracts in business. This is the second webinar in a four-part series on the psychology of contracts, where we will explore managing business and partnership expectations, defining the contract terms to minimize conflict, evolving the partnership agreement for successful continuity of the business, and contract considerations for online businesses in the digital economy. All discussions during the course of this webinar are the views and opinions of the speakers themselves and do not necessarily reflect the views of their employers or affiliates. The information provided does not constitute financial, legal, tax, or investment recommendations or advice. We are privileged to have joining us two esteemed panelists. Shabir Ladha is a chartered professional accountant with KBH. Shabir graduated with a Bachelor of Commerce degree from the University of Victoria in 1999. He received his CA in 2001, became a partner in 2007 after articling with KBH, and obtained a Family Enterprise Advisor designation in 2017. Shabir is a member on the Board of Directors and Chair for the Audit Committee for the Edmonton Community Foundation. Nadia Somani is a lawyer who specializes in corporate commercial law, with a current focus on charities and non-profit organizations. Nadia is the Senior Legal Advisor for the Aga Khan Foundation Canada, the Aga Khan Museum, the Global Center for Pluralism, and the Diplomatic Office of the AKDN Resident Representative to Canada. Prior to joining the Imamat institutions, Nadia was a partner at a Toronto law firm practicing in the areas of corporate and securities law. Business partnerships have many advantages as they allow entrepreneurs to pool complementary skill sets and share startup costs and risks with one another. Unfortunately, many of the advantages of partnerships can also be disadvantages, and statistics show that up to 70% of business partnerships ultimately fail. In a business partnership, it is very important to have a comprehensive agreement in place so that issues such as finances and the division of work are clearly spelled out before starting the business. We are fortunate to have with us today our presenters who will outline how to manage contracts successfully in business. Welcome to our panelists. Shabir, to start the discussion, could you define partnerships in the context of business and highlight the route to a successful partnership for us?
Thank you, Rosemin. In corporate law, there is a definition which Nadia is much better equipped to speak to here, but I don't think the legal definition is really what we're trying to get at in this case. The term partnership is really a relationship where two or more parties will come together to achieve a common goal or objective. Practically, that could be individuals, companies, or a mix of the two coming together in some way. Think of four individuals who want to open a restaurant, or one company loaning money to another. Maybe it's a mother and daughter, they're going to pool some funds and invest in a rental house. Or maybe a little closer to home, a uncle and father, two brothers come to Canada, can't afford to purchase a business on their own, but by pooling their resources, they have enough to buy a little bit larger business and earn an income for both families. it's an endless list of two or more parties that could come together to do something. And normally they'll have some sort of profit motive to them. A client of mine has a business. He's owned it for about 30 years, and he's ready for a partial retirement. Part of that is to create a partnership with one of his key employees who will then buy in. As part of that buy-in, we're going to create a unanimous shareholder agreement, which is a corporate version of a partnership agreement. And that agreement will govern how the two of them work together, resolve disputes, and share income. It also addresses what happens when things go wrong and how shareholders can get out. And so those pieces we'll talk about a little bit more shortly throughout the presentation. But a successful partnership really is a relationship, and it's a relationship that is based in communication. There's this old saying that in the absence of truth, people will make up their own story, and the story will always be wrong, or at least partially wrong. And so the communication can help eliminate the misunderstandings. And misunderstanding is what leads to conflict, which then can often lead to the end of the partnership. So back home, we operated in a different way. The community was small, the families all knew each other. Perhaps there was a little bit less of me and a little bit more of we as a culture and an attitude. And so deals could be made over chai and a handshake. And there was this common understanding that we were in it together, we would work together, we would do things in a certain way. And perhaps the transactions were potentially less complex than they are now. Fast forward to the Western world, society appears to have shifted a little bit, and we're a little bit more of a me, and transactions are a little more complex. And so now we tend to rely on courts and agreements to settle disagreements. These things have changed, and they've forced us to move away from handshakes. And so when we want to get into a partnership, I think there's 5 success factors that I would see that you really have to focus on. It starts with the right people. We don't normally get married without dating first or getting to know people first. And so if a business partnership, if you think of it similar to a marriage, 2 people or 2 groups coming together, why would you get into a business partnership without knowing who the person or the people are that you're going to get into business with? And so the right people. Along those lines, the right skill set. If everybody is of the same skill and you're missing some things, the partnership becomes a little bit more difficult. And the relationship has to be built on trust. So we start with the right people. Then we assign roles and responsibilities. Spread the work around. Maybe not equally, depending on what different people are doing, but spread it around. Play to people's strengths. If somebody's really strong in marketing or HR, don't get them to do the detail work. Let them do what they're really going to be good at. Lay out the expectations clearly and in advance so everybody knows what they're supposed to do. And money makes people uncomfortable. You need to talk about it up front. Everybody needs to understand where they are, what they're going to be paid, or how they're going to be compensated. So we've assigned roles and responsibilities. Once we've figured all of that out, put it in an agreement, write it down. You probably want a lawyer to help in this part. Then we start to work together, communicate, work hard, achieve those goals. And finally, this partnership needs some sort of exit plan. Every partnership needs an exit strategy of some kind. Even a marriage has one. It's called till death do us part. Death happens to be the planned exit. Sometimes plans change and things don't work out quite that way. But with an exit strategy, we make sure that nobody is stuck. Now, I can list off 5 things very quickly, and it sounds easy, but if it was easy, roughly 70% of them wouldn't fail. But with those 5 things in mind, a business partnership can be off to a successful start.
Thank you for setting the context of business agreements, Shabir. What are some of the exit strategies and transition planning that should be incorporated into the business contract?
So exit strategies generally take on 2 forms, planned and unplanned. The planned ones, those are the good ones. Those are the ones we like. They happen based on a known event or a known timeline. There's a discussion in advance as to when the partnership or the relationship business deal may end, under what circumstances. So planned ones, think of those, where I mentioned a loan by one company to another. Well, when that loan is paid off, the business partnership is ended. There's a timeline and it's known in that scenario. Perhaps you've invested in a rental property with an exit in mind being when it hits a certain market value or we've made X number of dollars, it's time to get out. Quite often businesses will have those timelines or plans in place. We plan to build this up, get it to a certain state, sell it off because it's worth X number of dollars. Or quite often in other business relationships, retirement age. It's time to pass the torch to somebody else or transition on. As a practical example, my partnership agreement includes roles of each individual, and they're defined, but the firm comes first in our agreement before our personal goals, before our personal gains. And so our agreement has a firm ending to it. It's a planned end. At age 60, I start my transition. At age 62, I walk out the door. And then there's pieces that are tied into this agreement to make sure it happens the way it should. So compensation is tied to me doing the right things during that 60 to age 62 period. If I wanted to leave early, I can. There's clauses and potentially extra costs for me to do that. But the agreement is very clear as to how anyone can exit from the partnership. It deals with when, it deals with how, it deals with the payments, all with enough detail so somebody understands what will happen on an exit. That's an ideal agreement for one of those planned exits. Unplanned exits can be disastrous. These generally arise out of death, blow up, some big disagreement, a dispute that cannot be resolved. And if they're not addressed in an agreement, the resolution becomes costly, time-consuming, and can be disastrous. And so agreements generally deal with these unplanned exits in a variety of ways. They address death of a partner. They may address instances where a partner gets divorced, goes bankrupt, maybe is unable to perform their duties as agreed upon. Maybe they've got mental or physical impairments that prevent some of that. And because they are sudden, they cause trouble. Nobody has time to prepare. Plans might not be put in place. It might mean having to hire somebody new in a rush or find a new investor, deal with a bank guarantee, whatever the case may be. If things are done hastily, they can have lasting effects. And so we really like to try and plan for these and put provisions in place to prevent those disastrous effects. And so the agreement will deal with a lot of this. And whether it's planned or unplanned, the agreement has a number of similar characteristics to deal with those two types of events. It starts with a triggering event or triggering thing. Something happened, planned or unplanned. We look at it, it occurs. Okay, what do we do next? Well, usually the next step is evaluation. What is the business worth and how will that value be split? And while there's many ways to deal with the value of the business, the agreement will dictate who will do it, by when, in what method or manner, and then address things like, well, if there was a malicious event that caused this, perhaps there's a discount to the value. Purposeful act by the partner can reduce value as well. And so something will happen within the valuation to tell everybody how much. Then the agreement will deal with a timeline. The exit will occur at one point that will trigger a transaction. How long before we actually have to do some? In the case of, say, physical or mental impairment, there may be a time period for a reconciliation, for healing, before we actually trigger an exit. In other cases, and I'll come to some examples later, the trigger might happen right away and the timeline is instant. And then we get to payment. So based on the valuation, how much will be paid? When will the payments begin? How long will the payments take? Will there be interest on the payments? Those kinds of things, provisions have to be in the agreement as well. And then finally, financing. How will these payments be financed? If there's a buyout or a payout in some way, will it be paid from personal funds of the remaining partner? Will there be a bank loan? Is there life insurance involved? Will ongoing business cash flows fund it? There's a lot of options that can come to play, but the agreement will lay out all 5 of those criteria. So a triggering event happens, evaluation is done, a timeline of what will happen, payment, and then finally financing. And so the key to exit and transition planning is to think ahead. Consider what might be and how would you go about doing it and how would you like it to go. In a perfect situation, what would happen? And if it's not well thought out and not agreed to, an exit can often mean the partners no longer speak again. They may never have family meetings or family dinners or anything else. Those tend to be the worst possible outcomes without the right planning.
Indeed, these are so very important considerations. Thank you, Shabir. Nadia, one of the areas that you specialize in is corporate and commercial law. Would you remind us of some of the important clauses that should be incorporated into a business agreement that would address the potential risk of conflicts in the future?
Thank you, Rosemin. And before I address your question, I just wanted to offer my gratitude for inviting me to be here with you, Shabir, and all the participants today. The topics being covered in this webinar series are so important as far as dispute prevention strategies are concerned for businesses, but they also have practical relevance in our everyday lives. Understanding contracting principles and feeling comfortable with contracts is, in my opinion, a life skill that should be developed by everyone, and like any skill, should be practiced regularly. In that sense, I'd like to respond to your question at a high level first, and then drill down to the particular clauses in business contracts, or even any other kinds of contracts, that one should look at or at least consider. So let's start with what a contract actually is in a legal sense, which is simply a recording of the meeting of the minds of the parties. So why is this relevant? It's relevant because it means that any contract, business or otherwise, must reflect the common understanding of the parties involved relating to the subject matter of the agreement. Relating this to your question then means that the most essential thing to include in your business contract is the actual business that has been agreed upon. And to get this part right, I recommend asking yourself and the other contracting parties involved a series of basic questions like the what, why, with whom, where, when, how, the what ifs, and the what thens. These are the questions to ask even before getting to the legal review or drafting, because if you get this part right, you would have already addressed about 90% of the issues that lead to disputes. The details here matter, and they should be outlined with as much specificity as possible and avoid ambiguity in drafting terms so that all parties are clear on their respective rights and obligations. Keep in mind that it's not just the lack of formally recording understanding that leads to disputes, but also in many cases, the looseness or vagueness by which a deal is recorded that leads to conflicts among parties. The what and the why are questions that I bundle together. The what is really just understanding what the business deal is and its terms, and why is the purpose and intent of the transaction or relationship. I like to see the what and the why set out in general detail at the beginning of a contract, which we refer to as recitals, because it sets the context of the rest of the agreement and anchors the terms in some overarching objectives that can be referred to in cases where, say, there's a lack of clarity in how a term in the contract should be interpreted. In effect, it helps to reinforce the spirit and intent of the agreement and the purpose of the arrangement. So we've got the what and the why dealt with, but what about the who? This might seem very obvious, but I've seen it all too often that a party that should have been contracted or included in a contract was not, leading to issues in recovery or redress when something went wrong. Ultimately, if a party has a right or obligation to do or perform something in your contract, consider whether they should be added specifically to your agreement. An example might be where you're doing renovations in your place of business and you have several trades performing the work. You would probably hire a general contractor who will hire and oversee the other subtrades. But if the subtrades don't perform as they should or cause damage, you might have difficulty recovering from them directly as your contractual relationship is with the general contractor or the GC. In this case, it doesn't mean that you need to hire the subtrades directly or that you need to contract with the subtrades directly, but you would want to ensure that your contract with the GC provides adequate protections for you as far as their work is concerned. And you might want to build out your clauses in your contract dealing with these third-party actors a bit more. For example, requiring a GC to provide you with indemnification for losses resulting from the subtrade's actions, and requiring the subtrades to add you or your business on their project insurance. At a more basic level, it is important that you clearly identify the person or body with whom you are contracting and engaging. Is it an individual? Is it a corporation? Is it a partnership? These details also matter when it comes to the terms that are included in a contract, the protections and recourse available, and even the signatories to the contract. This is especially relevant when dealing with partnerships or even self-employed individuals who offer their services and talents to businesses, but where their legal structure or vehicle through which they offer those services might not be apparent. So then we start asking ourselves the questions about the whens and the wheres. The where is rather obvious and self-explanatory, so I won't spend a great deal or any time on it, but I would like to devote a couple of minutes to the when. Ideally, contracts should include a term provision in some form or another, which defines the duration of the agreement and makes it clear when the contract comes to an automatic or natural end. It should also set out when various parts of performance are required rather, and how such performance will be acknowledged or accepted. Sometimes parties want to enter into an agreement for a set amount of time, but they might also want an option to renew or extend the contract for another term if things are working well. In this case, it would be valuable to include some terms around the renewal rights. Here, you might ask questions like, how many times can the contract be renewed? How and when must either party communicate their intention to renew? Do both parties have to agree to the renewal, or can it be done unilaterally? Is the renewal on the same terms and conditions, or do parties have to renegotiate certain terms like price? These renewal terms should be considered at the same time you are thinking about the term of the contract. The when question is almost always connected to payment terms and compensation as well. Sometimes payment might be due at the end of the contract term, making it even more critical to define the contract date instead of leaving it open to the parties to decide when all obligations have been performed, and which looseness can raise the risk of a dispute. At other times, there might be installment or progress or staged payments, which are tied to specific triggering events or defined dates, as in the case of a loan, or upon project completion, as in the case of construction contracts, or milestone achievements, as in the case of service or sales contracts. Whatever the case, think about all of the dimensions of time and how they might factor into the obligations and rights under your contract. Moving along to the how, I think it would be fair to say that having given thought to the whats, the whys, the wheres, and the whens, the how should be pretty easy or simple to answer. And what I recommend here is think about the how as it relates to the other components of your agreement. For example, if you have contracted someone to provide you with certain goods that need to be produced in a certain way, have you outlined those specifications with precision and without room for interpretation? Could the method of production or delivery be substituted if the other party wishes, or do they need to seek your permission? Every situation will be different, but thought should be given to the how, perhaps even while thinking about the whats. The next series of questions are the what ifs, and these questions are really centered around the risks associated with your arrangement or transaction. Think about things like what would happen to the payment terms if, say, a milestone is not achieved or is delayed, as we've seen to be a common occurrence during the pandemic. I find this is the part of the process that proves to be the most challenging for parties because they might associate risk identification and conversations around risk as being a signal of a lack of trust in the other party, or they might feel that it mutes the enthusiasm of the deal, or it might just feel like it's too negative or uncomfortable and they don't want to think about it at all because they're confident everything will work out and any issues can be sorted out after the fact. These are all things I've heard before, and sometimes things get managed without incident, but that's the exception and not the norm. I can't stress enough how important of an exercise this part is in facilitating dispute prevention. As uncomfortable as it is, explore the various risks, have a dialogue about them with the other party, and consider how they should be allocated between you and them. You also want to think about these risks and how they can be mitigated. Mitigation measures can be a combination of business and legal responses. I personally don't like relying solely on legal risk mitigation measures like waivers, releases, and indemnifications. Though they are important, I think once you are relying on these provisions, you're already, in most cases, at the point of a dispute or suffering from a breakdown of your business relationship. So I encourage those I work with to think about the non-legal risk management measures like insurance, but also finding other ways to lower the risk level, including having frequent check-ins or communication points with your counterparty to make sure all is operating as intended. Once you've gone through the process of identifying risks and building in mitigation measures as best as you can, you will want to look at the what thens. Shabir already spoke about why it's important to include exit clauses in your contract, and I would reinforce and emphasize his points as well. I typically look to include a termination without cause provision, meaning parties can terminate for any reason on notice to the other party and vice versa. I always like seeing these provisions because it helps one exit if circumstances change, and it provides a bit more flexibility to both parties to conclude an arrangement if it's not working out as expected. There are also termination clauses that get included for cause, where cause can be based on any number of things. Frequently, you will see these clauses tied to defaults like non-payment or bankruptcy of one party, or even the death of a party, but they might also speak to material breaches of the agreement or non-performance of the agreement. And all of these situations should ideally be included in your termination with cause provision. With a material breach, one needs to determine what will be considered material enough to constitute a material breach. For example, if you've ordered clear plexiglass divider screens for your cashiers in your business to reduce risks of COVID transmission, and you get ones that are black, is that a material breach? It's not what you ordered, but it does the job in providing a COVID barrier, but your cashiers can't see anybody. So in that sense, these COVID barriers that you received are probably of no use to you. But did your supplier know that? Was the purpose conveyed to them? Was it implied or understood? The materiality of an issue will depend on the facts, if something is material to you or not. And if it is, it should be noted in your agreement. In this kind of scenario, as well as others, you should consider whether a cure period should be negotiated, which is really a time to fix or remedy the issues or breach in question before moving to termination. I consider termination for cause to be the nuclear or last resort option. So I find cure periods to be quite a valuable right to include in a business agreement as a means of preserving the business arrangement, as well as preserving the relationships involved. Of course, they won't work in all situations, but consideration should be given to them. In all cases, though, one should make sure that the consequences of termination are considered and accounted for in the contract. What happens to payment obligations, for example? And what about documents shared with the other party? Do they get returned and destroyed? These are the kinds of things that should be thought through with care and dealt with in the termination clause.
I know that the webinar series has provided a great deal of valuable information on dispute prevention and the benefit of a dispute resolution clause. And I would encourage our audience to watch or rewatch those earlier webinars on the topic. But Nadia, could you speak briefly about these clauses?
Sure, thanks, Rosemin. You are right that much has been said about these clauses before, but worth reiterating here as it is also part of the what then analysis. As much as we might try to do everything to avoid disputes in the context of our business arrangements and otherwise, they do arise. So what then? I think it's a fair assumption that people want to avoid litigation in the courts, which can be costly. I don't think many people wake up thinking, hey, I want to speak to my lawyer today, other than maybe my family who have no choice but to speak to me on a daily. But this is where I find alternative dispute resolution or ADR clauses to be quite effective, including provisions that contemplate mediation and or arbitration help to manage the cost and timeline of resolving disputes, especially now in the wake of pandemic, where courts are completely backlogged and flooded with cases that are all delayed. ADR also has the benefit of managing public reputational risks associated with litigation, which some parties care very much about. Litigation is a matter of public record, don't forget. So these ADR mechanisms provide an expedited, cost-effective, and confidential way of resolving issues. We are fortunate in our community that we have the conciliation and arbitration boards that are equipped to hear and resolve disputes by willing parties, including business parties, at no cost. And I would highly encourage referring matters to them wherever possible and consider utilizing them where the need exists. I also like seeing clauses in contracts that identify pre-escalation points. And by that, I mean disputes would first get referred to a designated business lead. And if not resolved there, it would get escalated to a senior executive of each entity or the entities involved to find a solution. And only if a solution is not found at that point would one resort to mediation and arbitration.
These are all definitely relevant considerations and ones that should be carefully thought through. Are there other major clauses that you think are worth including?
Sure, there are, of course, various other standard clauses that often get included in a contract, which people don't really read very carefully or think very much about, but they all serve a purpose and do help in providing additional clarity around the obligations of the parties and mechanisms for managing the business arrangement over time. I mentioned indemnities, releases, limitation of liability, as well as insurance. But there are other clauses like force majeure, which is a clause that relieves a party from performing its obligations under a contract, either on a temporary or permanent basis, in situations where an unforeseeable event, not within the control of the party relying on it, occurs, like an act of God, such as a flood or a fire, which are natural disasters, or even things like COVID-19. There is also what we call a survival clause, which speaks to those parts of a contract that live on after a contract is concluded, such as confidentiality obligations or non-disparagement provisions, as well as others. I also look for amendment clauses that define how contracts can be modified by the parties, and I prefer that the amendments will only be effective if agreed upon in writing by the parties and done through a formal instrument. And where we have parties from different jurisdictions, different parts of the world, or different provinces, the governing law clause is also very important. And it tells you which law of which party governs, or some other law that the parties might have determined or established in advance. These are all clauses that have legal and practical meaning and implications and should not be overlooked or dismissed. And I suggest working with your lawyer on these provisions and understanding what they mean and how they should be customized for your situation.
Shabir, in hearing Nadia's overview, have you encountered situations in your practice where the lack of any of these terms has caused a breakdown in the business relationship? It would be helpful, I think, if you and Nadia could share with us some examples you have come across in your professional capacity, and maybe one or both of you could speak to how would a properly thought out business agreement have mitigated the financial loss or business continuity in these cases.
Unfortunately, there's many examples, but in the essence of time, I'll speak to two specific ones. The first one I'll think of, names are being changed to protect the innocent, or not so innocent perhaps in this case, but John and Ben were brother-in-laws. John was married to Ben's sister. John, Ben, and a third individual started an engineering business, operated for years, no agreements in place, everything went really well. Time goes on and a large international contract comes up. The contract requires the parties to have life insurance. It's part of the agreement. Life insurance agent puts the policy in place and recommends a shareholder agreement to deal with, as Nadia touched on, some of these other issues that come up, including how to deal with insurance. The agent has a sample agreement with a number of boilerplate clauses, which most people understand if they're used without care can cause some issues. And so this to us was bad sign number one. John's getting on a plane to close this deal, hastily signs the agreement without review by legal counsel or the accountants. Bad sign number two. They knew the agreement was not perfect, but though it was good enough, they were getting along, they were busy, the business was growing, and so it wasn't a priority for them. Years go by, and despite our urging and urging of legal counsel, the agreement is not reviewed or revised. It's bad sign number three. And I can just see Nadia cringing as I walk through this. And eventually, Ben retires from the company. John would like to buy Ben's shares back and assign them to young up-and-coming engineers, but Ben doesn't want to sell at a reasonable price. Turns out that the exit provisions in the agreement are unclear, not very useful, and so Ben does not have to sell, and there's no mechanism to force him to sell. Years go by, resentment builds, young talent leaves. Thankfully, the business is still successful. Finally, John offers Ben a price that Ben is willing to accept, a 25% premium above fair market value. That whole transaction concluded 10 years ago. Ben and John still do not speak. The relationship between Ben and his sister, John's wife, ruined, and they never get together. I'm not sure that it'll ever really be repaired. And so if we look at what happened here, an agreement was created in a rush with little consideration for how, when, and all of the other questions that Nadia touched on. The agreement was provided with an insurance agent. He's knowledgeable, he had good intentions, but he's not a lawyer. And so the agreement was not reviewed by any other professional advisors, lawyers or accountants who have knowledge in these areas and see things differently. They look at things from different viewpoints. And so as an accountant, I'm looking at business and tax implications of an agreement. And obviously the lawyer is looking at enforcement, conflicts, the overall legality, and a number of other points that are there that Nadia already touched on. And so without this agreement and then being not reviewed or updated on a regular basis, there was no provision in place to help these two when we finally needed it. On the opposite side of outcomes, I'll think of an example with a pharmacy that I have. Ownership has a number of pharmacies, and these have minority partners in them as well. One particular individual as a minority partner in a pharmacy happened to have a substance abuse problem, which nobody knew about. But a pharmacist with a substance abuse problem and access to narcotics, really not ideal for a scenario. But day one, when the minority partner came in, we had a shareholder agreement in place. It governed all kinds of things that I've talked about, covered off these questions that Nadia touched on. We had a really knowledgeable corporate lawyer that created it. Our office did a final review, made sure everything made sense from all sides. This unplanned event that I touched on occurs. In this case, the pharmacist got caught stealing and his substance abuse problem was revealed. The agreement dealt with the exit of that partner in this unplanned scenario. There were no questions about what to do or how to do it. We simply followed the process. Business was valued. In this case, it was an unplanned event that was the fault of the minority partner. So a discount was applied based on the payment in the agreement. Payment terms were known. Payment was being made over 3 years out of business cash flows. So financing was known. The lawyers drafted all the necessary agreements and regulations to get the individual out of the business. Everything was finalized in a short time frame, and everything went on as planned. Just to close the loop here a little bit, the individual did get help. He's been clean for years. He and the partners are still on speaking terms. They may never get back into business together, but they are on speaking terms, and they still know what's going on with this individual's life. And so if we look at what happened here, a well-drafted agreement in place, thought put in advance in these what-if scenarios. The parties knew what would happen, and when something did happen, it was really easy to just pull out the agreement, walk through it, get the right people involved, and nobody had any unexpected outcomes because of this incident that really wasn't planned, but had been thought through.
Thank you for those interesting examples, Shabir. Nadia, do you have additional cases that you can share with us?
Sure. And Shabir, you're right. I was cringing. So look, Shabir, you had spoken earlier about the handshake deal, which is still very common today, and certainly not something I recommend, or I'm sure you recommend in any situation, really. I've had various cases where parties have come to me after the fact saying that they agreed to a deal with another party, sometimes in the context of a loan or an investment, but not always. And usually it involves their friend, a family member, or someone they have a pre-existing connection with. And that relationship sours because the promises that were made don't get fulfilled or honored as agreed upon or as expected. And I'll give you one example that took many years to deal with. We had someone who was a professional and who was rather business savvy, and that individual lent out money to a person they were familiar with to support a new business venture. They agreed on some basic loan terms, such as interest rate and term of the loan, and the borrower said that they would pledge one of their properties to secure the loan. But there was no formal agreement in place and no security agreements in place. For a couple of years, this arrangement was fine, or relatively fine, and the borrower was making the payments on time without real issue, but some payments were missed or not made at the time expected. Some payments were given in cash, and no receipts for the loan repayments were given. And then things changed. The borrower started to miss payments more frequently, and it was becoming harder for the lender to chase them down. The lender worried about the situation and came to our firm, my firm at the time, asking what could be done. So we tried getting the borrower to confirm or acknowledge their debt in writing, but they were reluctant to do so and started denying that a loan was even made and came up with their own version of the arrangement and claimed that the money was gifted. Luckily, the lender had a couple of texts and emails and other evidence that suggested that they didn't gift the money, but that it was indeed a loan. Using that evidence, the lender was able to get the borrower to acknowledge the debt, at least in partial form. And the borrower also agreed to start the process of securing the debt and having it registered against title to their property. But in the course of preparing the lending agreements to record the arrangement, the borrower died. The lender then had to continue dealing with the estate, which ended up becoming even more complicated, as I'm sure you can expect. So in the end, the lender had to settle on pennies on the dollar and spend a great deal of time, money, and energy on an issue that was so easily prevented. Had an agreement been in place at the outset, I wouldn't be using this example, and all the parties would have been better off, except maybe the lawyers who are really the only winners in these kind of situations. So instead of giving another example of a dispute arising from a lack of a contract, I'll share an example of the types of disputes that can arise when terms aren't fully developed or articulated in a contract that has been entered into. In one of the cases I had dealt with in the past, two businesses entered into a very common agreement for the development and redesign of a website, which cost in the tens of thousands of dollars. Here we had two sophisticated entities who had never dealt with each other before, but the business leads on each side developed a good rapport with one another, and they both felt comfortable managing the project between themselves. Each of the parties had their own staff supporting the project, and in fact, one of the reasons the designer was chosen or selected was because of the team they had assigned to the project. The website company drew up a basic contract that set out the project in very high-level terms, and neither party had it reviewed by legal counsel. What was an issue? The contract set out a few principal terms, such as the fact that the redesign was to be done in phases, and it set out the dates those phases would be completed, and payment installments were to be tied to those specific dates. Seems pretty straightforward, except it wasn't. Lo and behold, the website designer started experiencing some issues in their own company, financial and other types of issues, and several of their staff left, including those on the assigned website project. Inevitably, this led to some delays, but it also caused quality issues in the deliverables that were provided. The business that engaged the website designer had raised their concerns, which were shared with the owner of the website design company, but that owner was already under a lot of financial and other strain, and they needed money from this contract to stay afloat. In ordinary times, maybe the owner would have been more responsive and helpful, but in this case, they had argued that they had delivered what was promised or contracted for, and that regardless, payment was due at the date intervals specified in the contract, which the owner construed as being fixed dates. The owner also argued that it was not a condition of the contract that the project team remains static, and that they were free to substitute other team members as they wished. They also argued that they had received approvals on the deliverables that they had provided and the work that they performed, because the business's junior associates or junior staff had accepted the work. As expected, the business that engaged the designer disagreed with all positions, and they argued that it was understood that the project team, in fact, verbally agreed that the project team would stay as is for the duration of the redesign, and that any approvals for work submitted would only be given by the senior project lead and not the junior staff. They also took the position that payments were tied to acceptance of deliverables, and that if the deliverables were delayed or not accepted to the satisfaction of that business, the payment timelines would naturally be adjusted accordingly. Unfortunately, since the contract didn't contemplate how delays would be dealt with, or how critical elements of the contract, like project team composition or adjustments to project schedule, since those types of issues weren't defined within the contract, the parties had an irreparable breakdown of their relationship and weren't able to reconcile their positions. The business just wanted out, but couldn't because there was no termination clause they could rely on, and the website designer owner demanded payment for work done, or they would take the matter to court. At the end of the day, the business couldn't prove that there was a material breach of the terms, and they decided that it was just cheaper to pay out most of the contract value than to take the matter to court and litigate. Well, that was the most rational economic decision for the business at that time. It still cost them a lot of money, time, aggravation, and they still needed a website to get redesigned. Most, if not all, of these issues could have been avoided had the business paid more attention to the contract and its terms, and had they included terms that they had verbally agreed to, as well as including other protections.
Thank you both for those engaging case examples. Nadia and Shabir, the trend is for new business ventures to be in the technology industry or an online business. What guidance would you give to entrepreneurs creating an online store or business with a few friends? And what about marketing or other joint contracts that an entrepreneur or professional providing consulting services may temporarily engage in? Does the digital economy and does an online business require modified business contracts or unique contract terms? Nadia, would you like to address the question?
Thanks, Rosemin. It's a great question and one that I deal with frequently at the museum, and especially now giving our growing digital presence and offerings, which I hope everybody here today and watching have been able to take advantage of. There really is something for everyone. And I know it's a shameless plug for the museum, but I'm sure it's one that nobody minds. So look, at the outset, we must remember that all contracts, regardless of their nature, should still have the fundamental elements I spoke about earlier, including details about the business arrangements agreed upon, as well as ensuring that there are safety valves in place to manage scenarios when things are not going as planned, and mechanisms for addressing disputes if they arise, and they do arise. But the specific clauses and business points to include will necessarily depend on your context and the nature of your entry or existence in the digital space. That is, what is the nature of the agreement being considered, and what is your role? Are you an investor? Are you a content creator? Are you a supplier? Are you a consultant? For example, if you're a content creator, you will want to ensure that third-party intellectual property rights are respected and enforced, and that you've obtained the necessary licenses or permissions for other people's work that you've integrated or are incorporating into your own. Similarly, if you are a business seeking to engage a content creator, you will want to ensure that the party you have engaged has given you all of the rights that you need to distribute or use the content that you've contracted or received. At the museum, for example, we spend a good amount of time negotiating these rights with artists or performers and even their agents. But this could also be true for a business that is, say, engaging a graphic designer to update their website or create a new marketing video or ad, or in other situations. On the topic of rights, it's also important to determine ownership of intellectual property rights. Taking the content creator example again, it might be that you are agreeing to give over all of your rights to the business engaging you. And as a business, you might prefer to have that level of control over it because it allows you to use the content as you wish in the future without additional cost or the need to seek approvals from that content creator. But in other cases, the content creator might just provide you with a license or a right to use the material or content such that they retain the ownership of the intellectual property rights. Here, the terms of the license being given should address things like use parameters, duration, the terms of the royalties, for example, exclusivity rights, as well as any restrictions. All of these things should be negotiated in advance and reflected in the agreement. If you're a business dealing with or in data, you will also want to ensure that you and the providers you are working with have appropriate data protection and privacy provisions and protections in place, and safeguards that will help you stay on the right side of the law, but equally important, that provide confidence to consumers, businesses, and the data subjects that interact with you. In the case of an investor in the digital economy, your considerations will clearly be different than those that I've just gone over. Yes, you will care that the business that you're investing in is complying with applicable laws, but you'll probably also care about how your financial investment is safeguarded. And here, you might want to bargain for certain information rights beyond the basics of what the law might otherwise provide you with. In this sense, you might want to have, say, observer status on the board of the company you've invested in, or you might want to have a vote in material or fundamental transactions, and you can define what those transactions are. And you'll likely also want to have audit rights built into your funding documents to allow you to see how the company is performing. Certainly, these agreements can range in the level of complexity and involvement, but hopefully this gives a good indication of the kinds of additional questions to consider when dealing with tech contracts or any contracts in the digital space, really.
Thank you, Nadia, for that valuable guidance. Shabir, would you like to add anything to the same subject?
I think Nadia nailed this. The only thing that I would add is that if one were to think about everything you just heard, the comments could translate to many other businesses. As an example, the assignments of rights or royalties can also exist in a manufacturing case, not just content creation. And when one strips away the intricacies and specifics of different businesses, selling cattle versus providing computer services, or marketing services versus a landscape design business, and money lending, there are pieces that are all very similar, and people come together to provide a new product or a service to the market. But businesses in a digital space add complexities that create new answers to the various questions that Nadia listed that need to be considered in contracts and agreements. And so it's those differences, those intricacies that come up because we are in a digital space or dealing in an online world, perhaps not face-to-face or with physical product, that creates a little bit of adjustment and change in thought process when we decide to contract together.
Thank you, Shabir, for that additional guidance. That brings us to the end of the discussion. We would like to give each of you a few minutes for your closing remarks. Nadia, would you like to go first?
Sure. Thank you, Rosemin. It's been a real delight being here with you today and with Shabir, and I'm so encouraged that we have been able to have this opportunity to share best practice and learn from each other. If I could leave everyone with a few takeaways, it would be the following set of do's and don'ts. But let's start with the don'ts so we can end on a positive note. So first, don't look at contracting as a way of shoring up your litigation position and using it as a sword in legal combat. Yes, you should look at protecting your interests and have them covered off, but contracts should really be seen as enabling documents that support the needs and objectives of the parties involved. Next, I would say, don't think you need to have your contract written in complex legalese to be valid or effective. Contracts are always best when written in plain English and in language that is clear and understandable to all parties. And here I would also say, don't leave things out of your contract because you believe them to be understood. All critical terms, however obvious, should be recorded in your agreement. Now let's turn to the do's. Do enter into a contract to formalize your planned transactions or business relationships. Even existing arrangements that have not yet been recorded can be memorialized in writing and contracted for. Do ask questions, and a lot of them. Make sure that your contract deals with all of the big stuff and all of the little stuff, all of the details on things that matter now or could matter in the future. Do take time to think about, assess, evaluate, and plan for risks at the outset of your business arrangement. Do consult professionals, legal, accounting, and others prior to formalizing your relationships. These people will be your best friends in the time of a deal or a transaction. And lastly, I would say be enthusiastic about contracting. An effective contract builds confidence and trust between you and your business partners, as well as other stakeholders. And it helps maintain positive relationships with those partners. So enjoy the process. I assure you it's full of rewards in every kind of way. Thank you.
Thank you for that summary, Nadia. Shabir, your closing remarks.
Thank you, Rosemin. You know, one of the unanticipated benefits of participating in a discussion like this is the amount that I personally learn. After advising clients for over 20 years and helping them through all kinds of situations, there's always something new that comes up. And unfortunately, in an hour, we can only scratch the surface. And despite what I said about businesses being so similar, people are not. Their thoughts, their desires, their outcomes, they're all different. And it's for those reasons that those customized agreements need to be made up. Sometimes I will encourage people to think about a very certain what if scenario. We heard Nadia mention the lending situation that ended with the lender having to deal with an estate. And so think about what if your spouse, your partner, your children had to deal with this business situation after you pass suddenly. They're grieving, and then they have to sort out a messy business deal that is not properly documented. They have to guess at what you want to have had happened. Or you put the agreement in place and reduce the stress on everyone. To reiterate the 5 factors that I considered as a success list partnership, it's finding the right people, assigning roles and responsibilities, putting that understanding into an agreement, working together, and then exiting at the right time. And there's so many stories of business agreements that have ended poorly, and those are the ones we hear about. However, there's also thousands of business agreements and partnerships that end successfully. The partners had a well thought out plan, communicated effectively, took advice that was given to them, and found a way to wind up their agreement. We only tend to focus on the exceptions because that's where we learn so much. And it's from those stories that we are told that we remember that business partnerships are difficult, but can be a great thing. They allow us to play to our strengths, grow faster, and typically achieve higher highs than when we go it alone. I'd like to end with a very short proverb. It's said to be of African descent, but one I've heard maybe from other sources as well. If you want to go fast, go alone. If you want to go far, go together. Business partnerships are not about going fast. They're about going far, and very often can be very rewarding as well.
Thank you, Shabir and Nadia. Thank you to the communications team for their outstanding support. And thank you to all the viewers for joining us for today's discussion. This session has been recorded and the webinar will be available at iicanada.org. The third webinar in this series on the psychology of contracts will be presented on Thursday, September 23rd, and is titled How to Manage Conflicts and Disputes over Contracts. In conclusion, I would like to quote Prince Amin Aga Khan from the Ismaili Economic Forum in Dubai in 2008, when he stated, "I would like to emphasize how essential it is that sufficient, careful, and dispassionate thought be given before partnerships and alliances are formed." Thank you again to our presenters for their time and insights on this subject. And thank you all for participating in today's event.